Hi there. This month we'd like to talk briefly about a concept in the law called the emergency doctrine. This is something that can be invoked by somebody who has been alleged to have caused a car accident, for example. But it's a unique doctrine and it has a very limited application. So, for example, um, number one, let me read the instruction a jury would get. A person who is suddenly confronted by an emergency through no negligence of his or her own, and who is compelled to decide instantly how to avoid injury, and who makes such choice as a reasonably careful person placed in such a position might make, is not negligent, even though it is not the wisest choice. So, number one, you can't apply this or use this in your defense if your own negligence was a component in creating the emergency. So if your brakes fail, but you have had this vehicle for years and never had it serviced and never worried about the brakes, and then they fail, well, your negligence in not maintaining your vehicle was a component in placing you into this emergency situation, and therefore this does not apply. Let's say you're driving down the freeway and there is debris that you couldn't see, and it's falling off of a truck a couple of lanes over and bouncing all over the freeway, and you swerve to avoid it and strike a vehicle next to you. In that circumstance, you may well be able to invoke the emergency doctrine. It was all of a sudden. You may not have made a perfect choice in swerving to avoid that particular piece of debris and in striking the vehicle next to you, but because you were placed into this situation through no fault of your own and had to therefore make immediate decisions that you wouldn't necessarily have even had the ability to think through completely, that is an appropriate and proper application of the emergency doctrine and would provide you with a defense for having run into the other car.